Hello and welcome to the Minimum Competence episode for Friday, September 5th, 2025. I'm your host for today, Andrew Leahy, a tax and technology attorney from New Jersey. On today's episode, Barrett on constitutional crisis denial, DOJ crackdown clashes, Trump's troop use paused, and Google hit with a $425 million privacy verdict. Let's remember, the thoughts that come often unsought, as if it were dropped into the mind, are commonly the most valuable of any we have. And read today's legal news. On this day in legal history, September 5th, 1774, the First Continental Congress convened in Philadelphia, marking a critical early step toward American independence. Delegates from 12 of the 13 colonies, Georgia being the sole exception, gathered at Carpenters Hall to coordinate a colonial response to the Intolerable Acts, a series of punitive measures imposed by the British Parliament in the wake of the Boston Tea Party. These acts, which included the Boston Port Act and the Massachusetts Government Act, were seen by the colonists as severe violations of their rights as Englishmen. The Congress brought together influential figures such as George Washington, John Adams, Samuel Adams, Patrick Henry, and John Jay. Though the colonies had differing interests and levels of loyalty to the crown, the delegates united in their desire to assert colonial rights through collective action. They adopted the Suffolk Resolves, endorsed a boycott of British goods through the Continental Association, and agreed to reconvene the following year if their grievances were not addressed. Rather than immediately pushing for independence, the First Continental Congress aimed to restore harmony with Britain while defending colonial autonomy. It drafted a Declaration of Rights and Grievances, emphasizing allegiance to the crown, but rejecting parliamentary authority over the colonies in matters of internal governance. This Congress laid the groundwork for future intercolonial cooperation and demonstrated that the colonies could act in concert. Its organizational structure, with committees and formal resolutions, prefigured the eventual legislative model adopted under the U.S. Constitution. While King George III in Parliament ultimately ignored the Congress's petitions, the gathering significantly escalated the political crisis that would lead to the American Revolutionary War. Supreme Court Justice Amy Coney Barrett said this week that, despite political polarization and President Trump's aggressive use of executive power, the U.S. is not experiencing a constitutional crisis. Phew. Speaking at New York's Lincoln Center while promoting her new book, Listening to the Law, Barrett emphasized that the Constitution is alive and well and that American institutions, particularly the courts, are still functioning effectively. Her remarks come amid widespread concern over Trump's second-term policies, including sweeping immigration crackdowns, tariff impositions, and rollbacks of diversity programs, many of which have been challenged in court. Federal judges have repeatedly halted or delayed Trump's initiatives, leading to sharp criticism from the president. Earlier this year, Trump even called for the impeachment of a federal judge, raising alarms among legal scholars. Despite these tensions, Barrett asserted that a real constitutional crisis would require the collapse of the rule of law, something she doesn't see happening soon. Barrett also defended her controversial vote to overturn Roe v. Wade in 2022, arguing that Supreme Court decisions shouldn't be influenced by shifting public opinion. While support for abortion rights has grown in recent years, Barrett stood by the court's direction, which has taken a decisively conservative turn since her appointment in 2020. Her comments signal confidence in the judiciary's resilience during politically charged times. U.S. prosecutors are aggressively charging individuals in Washington, D.C. with assaulting or resisting federal officers under a new DOJ-led law enforcement push, but the initiative is drawing scrutiny due to its stark contrast with President Trump's earlier decision to dismiss or pardon many January 6th-related assault charges. A Bloomberg Law Review found at least 20 new federal cases that closely resemble charges from the Capitol riot, charges that Trump has largely wiped away. Critics argue that this inconsistency undermines prosecutorial credibility and raises concerns about politicization of the Justice Department. Some judges and grand juries have echoed that skepticism. In one case, a magistrate judge cited the January 6th clemencies in deciding not to detain a man charged with threatening a National Guard member. Prosecutors have also struggled to secure felony indictments, including in a case where a former DOJ employee was accused of throwing a sandwich at a federal officer. These outcomes point to juror reluctance in cases they view as politically selective. U.S. Attorney Jeanine Pirro is leading the local effort and has acknowledged the difficulty in securing convictions. Some cases involve more serious allegations, kicking, hitting, or spitting on officers, while others stem from lower-level confrontations, including a disputed video involving immigration agents. Meanwhile, defendants and defense attorneys are raising claims of selective prosecution, citing the dismissal of hundreds of January 6th assault cases still pending when Trump returned to office. One high-profile example involves Representative LaMonica McIver, whose lawyers argue her case, stemming from a confrontation with immigration officers, is being pursued for political reasons. Prosecutors have already been forced to downgrade multiple cases from felonies to misdemeanors due to lack of support from grand juries. A federal appeals court has temporarily blocked a lower court's ruling that would have restricted President Trump's use of military troops for immigration enforcement and crowd control in Los Angeles. The move preserves Trump's authority to use active-duty military and National Guard personnel in support of federal agents while the case is under appeal. The original ruling, issued by U.S. District Judge Charles Breyer, found that the administration had violated the Posse Comitatus Act, a law dating back to the 1800s that limits military involvement in domestic law enforcement. Breyer's decision, which would have barred military personnel from performing police functions in California, was scheduled to take effect on September 12th, but is now on hold as the Ninth Circuit reviews the appeal. The legal fight stems from Trump's June deployment of over 4,000 National Guard members and 700 Marines to Los Angeles during protests over federal immigration policies. Though most of the protests have since calmed, around 300 National Guard troops remain on the ground supporting immigration and drug enforcement operations. Critics argue that Trump's use of the military and civilian law enforcement roles marks a dangerous shift in executive power. The same day the Ninth Circuit paused Breyer's ruling, Washington, D.C. Attorney General filed a lawsuit challenging similar military deployments in the capital. Trump has also signaled interest in expanding military involvement to other cities like Chicago and New Orleans. Google has been hit with a $425 million jury verdict in a major privacy class action after a last-minute law firm switch brought Cooley LLP into the case. Originally led by Wilkie Farr, the defense team, headed by partners Benedict Herr and Simona Agnellochi, jumped to Cooley in June, just weeks before trial. Cooley, already a Google client, took over the multi-billion-dollar case and brought in additional lawyers to assist. The abrupt law firm change followed internal dissent at Wilkie over a controversial agreement with the Trump administration requiring pro bono work aligned with White House directives. The case centered on allegations that Google collected data from nearly 100 million users, despite their account settings indicating they wanted to keep their information private. After a 2-week trial in San Francisco, the jury sided with the plaintiffs, led by prominent attorneys from Morgan & Morgan, Bowie Schiller, and Sussman Godfrey. While the plaintiffs had sought $31 billion, the jury awarded just over 1% of that amount. Google said it would appeal, claiming the jury misunderstood how its privacy settings function. The plaintiffs' legal team, however, called the verdict a clear message about unauthorized data collection. The firms behind the case have brought similar lawsuits, including one over Google's Chrome incognito mode, which resulted in a settlement earlier this year that forced the company to destroy billions of data records. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading on all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment, leave a rating or review on your podcast player. We'd sure appreciate it. And if you know someone that might be interested in the story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly never that. Minimum Competence is available at minimumcomp.com and wherever you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. We'll see you back here on Monday. And until then, note, we like to close out the week of shows with a featured musical piece. That will make these Friday episodes seem especially long. We hope you'll stick it out and enjoy the featured piece. But if music, and specifically classical music, isn't your bag, we get it. Our mouth sounds unrelated to the week's closing music ends here. This week's closing theme is by Amy Beach. This week's closing theme features the elegant and expressive piano miniatures of Beach, one of the most important American composers of the late 19th and early 20th centuries. A prodigy and largely self-taught composer, Beach broke barriers as the first American woman to write a symphony performed by a major orchestra and became a central figure in the Boston musical scene. Her work spanned symphonic, choral, chamber, and solo piano music, all marked by lyrical intensity and harmonic richness. Composed in 1892, her 4 sketches, Opus 15, for solo piano offers a vivid, compact display of her early voice as a composer. Each short piece evokes a distinctive atmosphere. In Autumn captures seasonal change with swirling colors. Phantoms conjures mysterious shadows, Dreaming drifts into quiet introspection, and Fireflies sparkles with quick, darting motion. Though brief, these character pieces are finely crafted, offering emotional depth and technical elegance. As our closing music, Beach's Sketches reminds us how much can be said in miniature, and how, even in the most restrictive musical culture of her time, she composed with clarity, beauty, and unmistakable individuality. Without further ado, Amy Beach's 4 sketches, Opus 15. Enjoy.